Hello everyone, I am Rupam, a practicing advocate with core expertise in arbitration and litigation of civil matters, including law governing companies. We are seeing a high rise in the number of petitions by tenants seeking exemption of rents. So I thought to share some light on the legal positions for payment of rents, whether you're a commercial tenant or a residential tenant or a landlord. Now, after no order or direction by the Supreme Court in this regard, the Delhi High Court has recently given a detailed judgment and view on the position of payment of rent during the present quarantine in the case of Ramanand versus Girish Soni. If you're a landlord, you're worried because you've stopped receiving rents, and if you're a tenant, then you're worried because of no running business. You do not have the paying capacity to pay out your rents. So the most common dispute today is of waiver or exemption of rents for the time our shops, business or other commercial establishments are closed. Now several classes of tenants such as labour, students, workers, they've all been granted protection by the government. But what about others? Before that, let's understand the kind of tenancies existing under the law. Now, first is the oral tenancy, where there is no written agreement between the landlord and the tenant and the rent is orally decided and payable every month. Second is the short-term tenancy agreements or the written rent agreements, which record the rent amounts payable every month. Then there are long-term lease agreements. Those are the agreements with detailed contractual provisions such as force majeure, which we will discuss later. Then there are lease agreements structured as revenue sharing agreements, which means that agreements where revenue or profits are shared between the tenant and the landlord and not monthly rent payments. Similarly, agreements where a percentage of sale turnover is paid to the landlord. These are basically the main category of tenancies that are going to be affected. All those tenants who are on Pakdi tenancy or old tenancy, they are not affected because the rents of such property is very low as compared to the market rates. Similarly, for the residential tenants, they are also not much affected because they continue to reside in their houses even during the lockdown or today. So they cannot seek suspension of rent. It is only with regard to the commercial properties as tenants are out of business and some haven't occupied the premises anymore. Now, there are many pleas that a tenant can take, and we are currently seeing that the tenant relies on, which are based either on the contractual provisions or the precedents. Now, let's discuss those pleas, whether they are in favor of the tenant or not, in the light of the judgment that has been passed by the Delhi High Court. Now, first is force majeure. The occurrence of force majeure event protects a party from liability for its failure to perform a contractual obligation, which means a tenant failure to give rent to the landlord. Then typically force majeure events basically include an act of God, any war or warlike situations, epidemics, pandemics, etc. The intention of a force majeure clause is to save the performing party, which is the tenant, from consequences of something over which it has no control. So the tenant says that I have no control over this situation today and therefore I cannot pay the rent. But force majeure is actually not an exception to what would otherwise, it is an exception to what would otherwise amount to a breach of contract. But the force majeure clause does not excuse parties' non-performance entirely. That's the most important part for a tenant to know, that it does not, even if you have that clause in your contract, it does not excuse you to non-perform or not pay rents entirely. It just suspends the performance of the contract for a period of the force majeure, for the period of that when that event is there. The main important point is actually that it is not the COVID-19 which has led to this situation between the tenants and the landlords. It is the imposition of the mandatory quarantine imposed by the government, because of which premises can't be used. Now, economic hardship of the tenant is not a reasonable excuse for the tenant to not pay rent or perform its part of the contract, and this cannot be escaped under protection provided by the force majeure clause. But only if you have a force majeure clause suspending or waiving rents in your agreement, then you can claim suspension of rent. So it's very important that what are the wordings of the of your contract with your landlord, and whether that contract contains a clause which allows for suspension of rent, then you can claim it. Otherwise, because COVID-19 itself or the pandemic itself has not been declared as a force majeure event, and it actually depends from a case to case. So you cannot claim the suspension of rent. Also, because you are out of business and this economic hardship that you are facing, you cannot seek suspension of rent based on it. The also one point is that if the contract covers the even if the contract covers the present lockdown as a force majeure, it is important to ascertain the consequences provided for. Now, many contracts only provide for termination on occurrence of a force majeure event. Now, which means that even if the lockdown is there in your as a force majeure event in your contract, you have to see what consequences follow, because there might be contracts which only provide for termination of the contract or for a certain period of time, but it does not provide for suspension of rent. Therefore, a force majeure existence of a force majeure clause can only give you a claim for suspension of rent, but otherwise you cannot take the plea of the force majeure clause. Then now next is the frustration of contracts. Contracts which do not have force majeure clause can take a plea of doctrine of frustration of contracts under section 56 of the Indian Contract Act. No, it says that no contract or no law can compel you to do something which is impossible. But this doctrine will not apply to lease agreements because the contract is still in effect and some part of the contract has to be continuously performed. It is not basically a completed contract. So unless you have a completed contract where you are not paying rents every month, you can not claim the doctrine of frustration of contract. So this doctrine is also not helpful for the tenants. Now let's look into the factors that the court will determine whether you as a tenant on presentation of a petition to seek suspension of rent will be entitled to such a claim or not. First is the nature of your property, whether you're a residential tenant or a commercial tenant. Then the financial and social status of the properties, where is it located, what kind of rents that you have to pay. Then any contractual conditions, whether your contract contains such a clause of force majeure, whether your contract contains a clause of suspension of rent, what does your contract say on it, or whether it is silent. Then also if you have any protection under any executive order, protection either by the landlord or by the tenant. Now in respect of the contracts which are not classic tenancies or lease arrangements which do not mandate predetermined monthly rent, like the contracts in which you have in which the tenant pays a percentage of the sales or revenue to the landlord, in those cases the nature of the contract is a very important point that the court will see to determine whether you should pay rent or not. If you are not earning profits, then obviously you are not entitled to pay to the landlord. What were the main findings of the Delhi High Court in the judgments in view of the tenancy and dispute? The fundamental principle was that the relief would be available only if the government order or the pandemics, they are conceived as force majeure events, and if the contract provides for waiver or suspension of rent. Only if these two things are present, you were entitled for suspension of rent. The court held that mere temporary inability to access and use the premises cannot allow the tenant to suspend payment obligations unless the contract provides for the same. Then the court also held that if the tenant wishes to retain the premises, then the rent shall be payable by the tenant even for the period of the lockdown. If the payment of rent is linked to the profit sharing revenue basis, then obviously you can claim exemption of rent. And if there is a minimum guaranteed rent in the contracts, then and if the suspension of rent is not given in your contract, then such minimum guaranteed rent has to be payable by the tenant. So these were the main things that the court held, that if you are still in possession of, if the tenant is still in possession of the property, and then the tenant has to pay the rent and it cannot claim exemption. We all know that this is a difficult time and situation for both tenants and landlords. For what we have discussed till now, it is clear that the law is not in favor of the tenants, but at the same time, the landlords are facing shortage of income, which may be their primary source of income to survive. I think it may be also difficult to find a new tenant, and the property may lie vacant for a long time, which is why I think this is a perfect case for mediation. It will aid both the tenants and the landlords, whether financially or to save your time and cost. Now, mediation is hassle-free and it takes less time. If mediation is successful, then it will have the force of the contract and immediate relief to both the parties. I'm giving you certain points that you can negotiate during mediation to make it a successful mediation. The parties can agree on deferred payment of rent along with interest, which means the tenant can be allowed to pay the rent later on for the period of the lockdown, or the parties can agree on a temporary waiver of rent, so that to maintain the long lasting relationship or not face a situation where you are out of income because the property is vacant. It is very difficult to find tenant today who can pay such high market rates. You can renegotiate your terms of tenancy, increase or decrease the rent. Then the parties can also agree that the tenant can pay full rents on once his business has been restored, and obviously option to the tenants can also be given to later match the market rents. When the government or the PSU landlords should also consider these options to negotiate. I would just like to conclude by saying that the decision of the High Court provides much needed clarity, especially in the COVID-19 times, on the questions pertaining to obligation of tenants to pay rent. It is clear that it is not the right of the tenant to seek waiver or suspension of rent from the landlord. But this is, I think, just first in line of many judgments that will be rendered by courts in this regard. But this judgment does set the benchmark for consideration for request for waiver or suspension of rents. Thank you for watching this video, and do let me know your feedback in the comments below. You can also contact me through my LinkedIn or email me. The links are provided here in the slide. Please subscribe to my YouTube channel to keep yourself legally apprised. Thank you.